Good day, viewers. So many people are paying less attention to the election petition proceedings that is seeking the disqualification of Bola Ahmed Tinubu as declared by INEC, the president of Nigeria. Now, this is the critical time about the election petition. I know that, yes, the judges will also reconvene the parties. I'm talking about the Labour Party, the PDP, the AMP, the INEC, the APC. So the judges will still reconvene them to adopt the addresses as they have presented it. But this critical period of time is the most important time. It's just like when you finish writing an exam. Yes, the question paper will be forwarded to your teacher. Your teacher will mark the scripts. That is exactly what is going on now. So the judges are not going to wait until after the adoption of the addresses before they will begin to look into the evidence and begin to plan what the justice they are going to pass will look like. No, as I'm talking to you, many things has been going on underground. And I think this is the most important time that we have to pay attention to what is really going on. This is the right time for us to applaud the judiciary, to take their integrity not for granted at all, because all eyes are on the judiciary. Now, I want to talk about the judicial precedents, because in every election petition, especially for the lower court, not for the Supreme Court, there is always tension when they are about to give judgment for every case. Why would there be tension? That is the judicial precedents. Now, what is judicial precedent? I'm talking about a source of law where past decisions by higher court will create law for judges to refer back to for guidance in future cases. Precedence is based upon the principle of stare decisis et non quita movere, more commonly referred to as stare decisis, meaning to stand by decided matters. Let me elucidate what I'm saying. For example, what has the Supreme Court ruled about the IREF? Yes, the Supreme Court has passed judgment about the use of IREF and the electronic transmission of result. What do they say? This is binding on the lower court, since this case is before the Court of Appeal sitting in the Abuja. So they must obey what the higher court has already passed. So that is the judicial precedents. They must refer to what the Supreme Court says about this. So when you look back, you will understand that the last judgment, I don't know if it is the first, but the last judgment the Supreme Court passed about the IREF is between Governor Adeleke of the People's Democratic Party and Oyetola. And you can go and read the judgment and understand that yes, that any result in the IREF that did not match the result declared by the INEC is invalid. That is what the Supreme Court have passed. So the decision is binding on the lower court, and there is no two ways about it. This is a critical time. Now, let us talk about the most controversial cases in this election petition. That is the issue of having the 25% vote before you could be declared as the President of Federal Republic of Nigeria. This is one of the most controversial. But people are not looking at what has Supreme Court says about this. Yes, of course, the Supreme Court has said something about this. In the case of Buhari versus Obasanjo, so many people are aware, and I think you're listening to me, you must have heard about this case, where the Supreme Court says that winning Abuja to be declared president is not compulsory, but having 25% vote in Abuja, it is mandatory. This is the position of the law. This is what the Constitution says. So if the Supreme Court has affirmed this judgment, and you could see before the election, all the whole parties, including APC, they are saying, oh my God, I don't think that these people will have 25% in Abuja. 25% in Abuja is compulsory. They even said it in the national television. But boom, immediately after the election, they saw that it is only P2B that got the percentage that denied both Atiku of PDP, the Tinubu of APC, Kwakwanso of AMPP, among others. All of them were denied the 25% vote in Abuja. Now, the issue has become 25% in Abuja is no longer necessary. But it is time for us to also to make all these things known to the public because of public's opinion. Because the judges also read the public's mind. They understand the public's opinion. They understand, yes, the public already knows the law. The public is expecting this according to the law. So they will find it difficult to waive their mind or to adjust to the pressure they must have been receiving, maybe towards bribery or all those things. So that is why it is very important for the public opinion to always sound louder than any other opinions, because democracy is all about the government of the people. So if the people have made their choice and through manipulation, the choice of the people, of the majority, has been denied, it is important for people to talk loud so that people will know that yes, there is an injustice that has been perpetrated. So this is the issue about the judicial precedents of 25% vote cast in Abuja. It is mandatory. There is no two ways about it. Even the former Chief Justice of Nigeria have said that Abuja 25% is compulsory. The senior advocate of Nigeria, Mike Ezekome, have said 25% in Abuja is compulsory. So many other people, including former Attorney General of the Federation, said 25% Abuja is compulsory. Then what are we expecting? Let us wait to see what the court is going to pass. But that is about the judicial precedents that the higher court has already judged about this case. Let us see what this lower court is going to do. We are in the critical time. In my own opinion, when you really study about these judicial precedents of the Supreme Court that this Court of Appeal must follow according to the Nigerian rules and culture of judiciary, you will understand why the disqualification of Bola Tinubu is so certain. And that is why the Labour Party is resolute in everything they are doing. This is what they said in their last address. Take your time and listen to the end.
Peter Obi, the presidential candidate of the Labour Party (LP) in the 2023 general elections, has accused the Independent National Electoral Commission (INEC) of cloning electoral fraudsters as leaders and wasting the time and resources of the country. In the final address filed before the Presidential Election Petition Court, dated July 23, 2023, Obi and the Labour Party warned that if the court failed to whip INEC into line to do its electoral duties reasonably, impartially and independently, elections in Nigeria would remain a fraud. Obi and LP accused INEC of abandoning its primary statutory responsibility as an electoral umpire. They descended into the arena, putting on the toga of a candidate in the election it conducted. The presidential candidate of the Labour Party said INEC tragically and embarrassingly spent 5.5 pages of its address defending the ground on the no qualification of the second respondent, Bola Tinubu. Obi and LP said, in the case of PDP versus Alichenu 2019, LP ELR 49199 CA, this honorable court admonished the first respondent, INEC, who appears to have misunderstood its public duty. Thus, often one finds cases where INEC plays games with election materials and would not allow the petitioners access to documents used in the conduct of the election, even with court orders to produce same, as in this case, thus playing the cards of the declared winner openly to frustrate the petition. Obi further submitted that pursuant to the mandatory provisions of the Electoral Act 2022, the INEC regulations and guidelines and the INEC manual, INEC introduced the use of modern technology for the conduct of the 2023 general elections. He said by this, INEC represented and assured that it would use the bimodal voter accreditation system, BVAS, for the accreditation of voters in the polling units and the upload of transmission of the result of the election in real time on the day of the election to the INEC results viewing portal, IREV. However, contrary to the requirements of the law and in manifest disregard of its own representations, the first respondent, INEC, abandoned and discarded the much expected upload and transmission of the result of the election in real time on the day of the election from the polling units to the IREV. Rather and very strangely, blurred, unreadable and inaccessible documents, images were uploaded by the first respondent to the IREV, purporting same to be the result of the election in various polling units. These blurred images and the inaccessible documents were purported to be the result of the election in the polling units. The net result of the upload of blurred images on the iRev was that the outcome of the election could neither be authenticated nor verified, and thus lacked credibility and transparency. INEC's contention that the collation of the election result remained a manual process is patently false and seems to have disregarded the express provisions of the Electoral Act, regulations and manual for the election. The collation of election results at all the stages of the election process provides explicitly for electronic transmission to the iRev, which is part of the collation system under the Electoral Act. The authority of the Federal High Court's determination in suite number FHC/ABJ/CS/1454/2022 relied upon the first respondent in its final address and heavily harped upon in its argument is par inquirium and in manifest contradiction of the binding later decision of the Supreme Court in appeal number SC-CV 508-2023, Oyetola vs. INEC, delivered on May 9, 2023, in 2023 LPELR 60392 SC. Despite the first respondent's claim that the hard copies of the forms ECHA were allegedly used for the manual collation of the election, which by that reasoning ought to be in the first respondent's custody or possession, the first respondent nevertheless gave to the petitioners as certified copies of the electoral forms, including alleged forms EC8As, blurred, blank, and extraneous documents.